Hindu law is one of the most ancient and complex legal systems in the world. It derives its roots from the Vedas, the oldest and most auspicious scriptures of Hinduism, which dates back around 6,000 years. Hindu law is not merely a set of rules, it embodies a way of life combining religious, moral, and legal principles followed by the Hindu population of the country. It has evolved over thousands of years to include traditions and codified statutes keeping up with the changing times. Traditionally, Hindu law is deemed to have divine origin, purporting to have been delivered by gods to sages and the rishis. But the modern Hindu law is a set of personal laws that govern social conduct of Hindus. According to Mullah's principles of Hindu law, wherever the law of India admits operation of a personal law, the rights and obligations of a Hindu are determined by Hindu law. Thus, Hindu law is subset of personal law in operation in India. A personal law is a system of rights and duties of an individual based on their religion. It includes areas like marriage, divorce, inheritance, adoption, and guardianship. In addition to Hindu law, India has the following types of personal laws. Muslim law, that governs the Muslim population on the basis of the Quran, the Hadith, and the Ijma, and more to signify regulations pertaining to marriage, divorce, and inheritance. The system allows polygamy, unlike any other personal law, and outlines specific grounds for divorce, which include adultery and abandonment. Muslim law emphasizes the right of women in matters of divorce, including the entitlement to maintenance. Its application in India is allowed by the Shariat Application Act of 1937. The Christian personal law is based on the Christian Marriage Act of 1872 and the Indian Divorce Act of 1869. The law provides for place and registration of marriage and a valid divorce of spouses. Parsi family law is governed by Parsi Marriage and Divorce Act of 1936 and recognizes the rights of Parsi women regarding maintenance, providing for both alimony pendent alite and permanent alimony. Importantly, the Act prohibits divorce within the first year of marriage. The Jewish personal law is based on the Holy Book of Torah and Jewish jurisprudence. Lastly, the secular personal law framework allows individuals from different religious backgrounds to form family units together without conforming to any particular set of religious customs. The law facilitates interfaith marriages and provides guidelines for marriage registration, divorce, child custody, and maintenance. The law is considered progressive, offering legal recognition and protection to marriages that may not fit within the traditional religious ideals. This variety in personal laws has arisen from the secular nature of the Indian Constitution and the fundamental rights provided to all citizens to practice, propagate, and profess their religions under the Article 25 to 28. The freedom to follow their religious practices in the matters of marriage, divorce, and inheritance is considered inherent to the same, contrasting personal laws with the territorial laws like civil and criminal laws, which are applicable to all equally irrespective of their religion within the territory of India. Conservatively, the term Hindu denotes all those persons who are born into or converted to Hinduism, but historically Hindu bastardized version of the word Indio used to denote the inhabitants of the river Sindhu or Indus, giving it territorial and not religious undertones. However, after codification of Hindu law and enactment of various acts like Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Adoption and Maintenance Act 1956, and Hindu Minority and Guardianship Act 1956, the term Hindu evolved as an inclusive concept. The following persons, according to Section 2 and 3 of the Acts, are Hindus for the purpose of these laws. 1. Any person who is a Hindu by religion in any of its forms of development, including a Veer-Shiva, a Lingayat, a follower of Brahma Samaj, Prarthana Samaj, or Arya Samaj. Any person who is a Buddhist, a Jain, or a Sikh. A person who is a Hindu by birth, legitimate or illegitimate, both of their parents or one of their parents are Hindu and they are brought up as a Hindu. Any other person domiciled in India who is not a Muslim, a Christian, a Parsi, or a Jew, unless it is shown that such person would not be governed by Hindu law. This raises the presumption that person who is not known to be a Muslim, Christian, Parsi, or Jew shall be considered to be a Hindu for the purpose of this act, including atheists and lapsed people. This law does not apply to members of the scheduled tribe under Article 366(25) of the Indian Constitution, except if there is a notification in the official gazette by the central government making the law applicable to them. Due to its extensive history and evolution, Hindu law finds its root in both ancient and modern sources. Before the codification of Hindu law, the ancient literature was the only source of the law. The ancient sources are divided into 4 categories. First, Shruti. This literally means what has been heard. The word is derived from the root shru, which means to hear. In theory, these are the primary and paramount sources of Hindu law and is believed to be the language of the divine revealed through the sages. The synonym of Shruti is Veda, derived from the root meaning to know. The term Veda is based on the tradition that they are the repository of all known knowledge. There are 4 Vedas, namely Rigveda, containing hymns in Sanskrit to be recited by the chief priest; Yajurveda, containing formulas to be recited by the officiating priest; Samveda, containing verses to be chanted by the seers; and the Atharvaveda, containing a collection of spells and incantations, along with 18 Upanishads or Vedantas. Vedas are not exactly treatises of law but contain a complete code of conduct of life with emphasis on dharma. 2. Smritis. The word smriti is derived from the root smri, meaning to remember. Traditionally, smritis contain those portions of the Shrutis which sages forgot in their original form and the ideas whereby they wrote in their own language with the help of their memories. Thus, the basis of the Smritis is Shrutis. They are human works, not divine revelations. There are 2 kinds of Smritis, Dharma Sutras and Dharma Shastra. The Dharma Sutras are written in prose, in short maxims or sutras, and Dharma Shastras are written in poetries or shlokas. However, occasionally we find shlokas in Dharma Sutras and sutras in Dharma Shastras. In a narrow sense, the word Smriti is used to denote the poetical Dharma Shastras. The number of Smriti writers is almost impossible to determine, but some of the noted Smriti writers enumerated by Yajnavalkya are Manu, Atri, Vishnu, Harita, Yam, Katyayan, Brahaspati, Vyas, Shank, Daksh, and Gautam. The rules laid down in Smritis can be divided into 3 categories. Achar, related to morality; Vyavhar, signifying procedure and substantive rules which the king or the state applied for settling disputes in the adjudication of justice, and Prashchit, signifying the penal provision for commission of a wrong. Third, digests and commentaries. After Shrutis came the era of commentaries and digests. Commentaries or tika and digest nibans covered the period of more than 1000 years from 7th century to 1800 AD. For the first part of the period, most of the commentaries were written on the Smritis, but in the later period, the works were in the nature of digests containing a synthesis of various Smritis and explaining and reconciling the various contradictions between the customs in Smritis and those in popular use. Some of the principal commentaries were Mitakshara, Dayabhaga, Smriti Chandrika, and Vyavhar Myuk. The evolution of different schools of Hindu law has been possible on account of different commentaries that were written by various authorities. The original source of Hindu law was the same for all Hindus, but schools of Hindu law arose as the people chose to adhere to one or the other commentary or digest for different reasons. The Dayabhaga and the Mitakshara are the two major schools of Hindu law. The Dayabhaga school of law is based on the commentaries of Jamutvahan in the form of digest of all the Shrutis and Smritis, and the Mitakshara system is based on the commentaries written by Vijneshwara on the Dharmashastra of Yajnavalkya. Fourth, customs. Custom is regarded as the fourth source of Hindu law. From the earliest period, customs or achar is regarded as the highest dharma. As defined by the judicial committee, custom signifies a rule which a particular family or a particular class or territory has from a long usage obtained the force of law. Customs can be local customs, the customs that are recognized by the court to have been prevalent in a particular region or locality, class customs, the customs which are acted upon in a particular class. For instance, there is a custom among a class of Vaishyas that the effect that desertion or abandonment of the wife by a husband abrogates the marriage and the wife is free to marry again during the lifetime of the husband. A family custom, the custom which is binding upon the members of a family. For instance, there is a custom in the families of ancient India that the eldest male member of the family shall inherit the estates. There can also be business or trade customs, the customs that bind the people that practice a given trade or business. In Devvani Achi versus Chidambaram case, the Honorable Supreme Court held that in order to become a custom sanctioned by law and binding on the people, the custom must be an ancient and continuous in practice. It must not be vague or ambiguous. It should be reasonable and should not oppose the well-established public policy or law. A customary rule must also be in the complete observation of the society. There are three modern sources of Hindu law: judicial decisions or precedents. After the establishment of British rule, the hierarchy of courts was established and the doctrine of precedent based on the principle of treating like cases alike was established. Today, the decision of the Supreme Courts and High Courts are binding on all the lower courts in India except where they have been modified or altered by later decision of the same or higher court. In the case of Luhar Amritlal versus Doshi Jayantilal, the place of precedent as a source of Hindu law was affirmed. Justice, equity, and good conscience. Occasionally, it might happen that a dispute comes before the court that cannot be settled by the application of any existing rule or law in any of the sources available. The court cannot refuse to settle the dispute in the absence of law, and they are under obligation to decide such cases on the basis of the basic values, norms, and standards of fair play and propriety. In terminology, this is known as the principles of justice, equity, and good conscience, or natural law. According to the case Gurunath versus Kamlabai, this principle has enjoyed the status of a source of law since the 18th century, when the British administration made it clear, in absence of a rule, the above principle shall be applied. Legislations. Legislations are acts of the parliament which have played a profound role in the formation of Hindu law. Both before and after India achieved independence, some important sources of Hindu law were codified. Before independence, we had the social reform laws like the Caste Disability Removal Act 1850, the Hindu Widows Remarriage Act of 1856, and the Child Marriage Restraint Act of 1929. After independence, we codified other aspects of Hindu law, leading to the creation of the Hindu Marriage Act 1955, the Hindu Adoption and Maintenance Act 1956, the Hindu Succession Act 1956, and the Minority and Guardianship Act 1956. After codification, any point dealt with in the codified law is final. The enactment overrides all prior law based on custom or otherwise, unless the express saving is provided in the enactment itself. In matters not specifically covered by the codified law, the old textual law continues to be applicable. In conclusion, Hindu law is a dynamic and evolving legal system that has its root in ancient scriptures and customs. Its application spans various personal matters, ensuring the protection and rights of individuals within the Hindu community. Modern reforms and judicial interpretations have played a significant role in aligning Hindu law with the contemporary values and human rights principles, and will continue to do so as the society progresses.